The mics aren't on yet. Okay, so right now they're seeing that. So I would stand behind there because what's on that screen is what's on your YouTube. So you're kind of cut off right now.
No, I was going to be at the lecture.
Okay. Okay.
And is it live now?
If you would like to be.
Yeah.
Yes, that mic is on. The podium mic is on.
I apologize for the delay. We have a little technology problems. Not that I know anything about that. Welcome and thank you all for attending the program. Those of you who are here in person, those of you who are streaming, which I hope is working, and those who will watch it in the future. Tonight we're presenting an informational, nonpartisan program on the state of women's health and reproductive rights in Wisconsin. Whether you agree or disagree with the Supreme Court's decision to overturn Roe v. Wade, tonight's presentation is to inform us of where we are right now in Wisconsin regarding women's reproductive health. There's lots of confusion out there with different states enacting different laws, so we want to clarify what's happening in Wisconsin right now. Over the years, the League of Women Voters of Manitowoc County has fought to improve our systems of government through education. Thus, we have presented many programs and forums, made significant contributions to the community. Last year, we had programs on redistricting, ranked choice voting, voting and election information. Next month, October 20th, at 6 p.m. at the library, there will be a presentation on how to get your name on the ballot, and will feature 2 city clerks, the county clerk, and a newly elected alderman. Of course, we also have our long-running community collaboration around Great Decisions programs each year, which have been, in fact, the most well-attended programs in the entire state. We actually beat Madison. So thanks to all of you who attend that. We also study issues important to the community, and then we release a publication. We've had a poverty and addiction study, one on mental health resources in the county, and a recent one making a case for a mental health treatment court. After our speakers, we will have about 30 minutes for a question and answer time. I will ask that you come to the podium and ask your question, make it brief, and indicating to whom you're addressing your question. Tonight's program speakers in order of speaking are Attorney Hannah Jurss, who is an Assistant Attorney General in the Wisconsin Department of Justice's Special Litigation and Appeals Unit, then Dr. Dorothy Skye, who's an OBGYN, who earned her MD from the University of New Mexico in 1978, and finally, to wrap up our speakers' presentations and to present the League's position and action plan, Debra Cronmiller, Executive Director of the Wisconsin League of Women Voters. So our first speaker, Attorney Hannah Jurss. She served as counsel on many high-profile government litigation matters, including litigation concerning abortion law, COVID-19 measures, and constitutional separation of powers. Before joining the DOJ, Hannah spent 7 years as a post-conviction and appellate attorney for the Wisconsin State Public Defender's Office. Hannah has represented Wisconsin in argument before the United States Supreme Court and has argued 12 cases before the Wisconsin Supreme Court. She is a 2008 graduate of Kenyon College in Ohio and a 2011 graduate of the UW Law School. So without further ado, I introduce and ask Attorney Hannah Jurss, sorry. Thank you.
Thank you very much.
Hi, everybody. Good evening. Set up. It's a privilege to be here. Thank you all for being here, and thank you very much to the League of Women Voters of Manitowoc County for having me. I'm one of the attorneys with the Wisconsin Department of Justice representing Attorney General Call and the additional state plaintiffs in our lawsuit challenging the enforceability of what has been commonly referred to as Wisconsin's 1849 criminal abortion ban. Tonight I'm going to be talking about the conflicts within Wisconsin law on the books regarding abortion and our suit in which we hope to provide clarity for the people of Wisconsin. What is the law on abortion in the state of Wisconsin? When is it or is it not a criminal felony for a physician to provide a woman with an abortion in the state of Wisconsin? That these questions need to be asked at all, and that the answer is not easily apparent from reading the laws on the books in the state of Wisconsin reflects one of the core reasons why our lawsuit is so important and why we filed it within days of the Supreme Court's decision in Dobbs. One of the most fundamental principles within our rule of law is that we all should be able to know what the law that governs us is, so we can be on notice of what is and is not illegal before we act. And this fundamental principle is extra important when we're talking about criminal laws, because then we're talking about the potential deprivation of freedom and the loss of many other rights for a violation of the law. So before we get into the laws on abortion in Wisconsin, let's imagine two hypothetical laws addressing the exact same subject, but this subject is pedestrians crossing the street. Let's say the first law says, if oncoming traffic has a red light and the walk symbol is displayed, pedestrians may cross the road. The second law says, it is illegal for pedestrians to ever cross the road under any circumstances unless it is necessary to save another pedestrian from being hit by a vehicle. Those two laws cannot both be the law at the same time. They cannot coexist. They directly conflict. One articulates circumstances under which pedestrians may lawfully cross the road, even if another pedestrian's life is not at risk. But the other law says that engaging in the exact same behavior that the first law tells us is legal actually is illegal. Both cannot be true at the same time. And yet, that is very, very similar to how Wisconsin's abortion laws that are listed on the books look right now, given the 1849 criminal ban. And before we dive into the history of our laws and how we got to that point of conflict, I want to stress one thing that Wisconsin law is very clear on as it exists today. A pregnant woman under Wisconsin law cannot be criminally prosecuted for obtaining an abortion, and that's Wisconsin Statute 940.13. So the conflict in the law on the books that we're going to be talking about concerns the circumstances under which it is or is not illegal for a physician to provide an abortion to a pregnant woman in Wisconsin. So let's talk history. I'm a proud student of history, and understanding the history of our laws and how we got to this point is important. So first we go back to 1849. Wisconsin is 1 year old as a state. And the Wisconsin legislature enacts the first version of what is today listed in Wisconsin Statute 940.04, this being the criminal abortion ban. But this version in 1849 only criminalized abortions after quickening, and quickening was generally understood at the time to be the time at which the pregnant woman detects fetal movement, that generally understood as occurring between the 4th and 5th month of pregnancy. And when Wisconsin adopted that law, that was reflective of the general understanding and attitude towards abortion at that time, that pre-quickening abortion was not generally viewed as a crime. But a few years later, in 1858, the Wisconsin legislature amended that law, removed reference to the word quick to create the near total ban that today is listed in 940.04 sub 1, with the only exception being when necessary to, quote, preserve the life of the mother. And that same year, the Wisconsin legislature added a related provision prohibiting the administering of substances or use of instruments on a pregnant woman with the intent to cure a miscarriage. And when the Wisconsin legislature did this in 1858, it was following in step with a nationwide trend at that time to criminalize abortion at any stage of pregnancy, with the only exception being when the abortion is necessary to protect or to preserve the life of the pregnant woman, what is sometimes referred to as the therapeutic exception. It also bears stressing that at the time the Wisconsin legislature enacted that near total ban into law, it would still be over 60 years before Wisconsin in 1919 would proudly become the first state in the country to ratify the 19th Amendment, recognizing women's right to vote. Now, though in Wisconsin and in almost every state across the country, these laws criminalizing abortion at every stage of pregnancy except when necessary to protect or to preserve the pregnant woman's life were enacted into law, what we know from the scholarship is that these laws were rarely, if ever, enforced. Though it would be until, Roe v. Wade was not decided until 1973. In that roughly, over a century, these laws were rarely enforced. Though most states had laws, like Wisconsin's, the scholars estimate that between the year 1900 and 1970, 1 out of every 3 to 5 pregnancies ended in abortion. Married women obtained most of those abortions. And so by the time we reach the 1960s, and this has become, the subject of abortion is becoming more and more openly discussed, both the proponents and opponents of near total bans seemed to agree that these bans, quote unquote, worked in the same way that the 18th Amendment, quote unquote, worked, that being prohibition, to stop people from drinking alcohol. People did not stop, it was just now officially illegal. So then we get to the 1960s, and more attention is being drawn, focused on women's rights and on abortion. And there are a number of factors that are happening all at once, but one thing that I found particularly interesting that I'll note is that in the early 1960s, there was an outbreak of rubella being a type of measles. And this particular type of measles, if contracted by a pregnant woman during pregnancy, including early in the pregnancy, could lead to severe birth defects. And so that outbreak became the focus of a lot of the discussion around abortion. And of course, that was just one of many, many factors being discussed. So then we get to 1970, roughly 3 years before Roe, and a federal court declares Wisconsin's 1849 ban unconstitutional. And in 1973, the United States Supreme Court in Roe v. Wade declared unconstitutional statutes criminalizing abortion at any stage of pregnancy unless necessary to save the pregnant woman's life. It held that doing so violated an individual liberty of the pregnant woman guaranteed by the Constitution. And in fact, Roe specifically listed our 1849 ban as one such law that it was declaring unconstitutional. So, after Roe, our 1849 ban, which had been openly disregarded and rarely enforced for the roughly 100 years that it could have been enforced, now became affirmatively unenforceable as unconstitutional. So then what happened? Well, then our legislature convened what it called the Special Committee on Pregnancy Options as part of an effort to assist lawmakers in revising Wisconsin law in light of Roe. And in 1985, our legislature passed a major act relating to abortion and pregnancy. And in that act, they did many things, but in particular, they passed a law that directly conflicts with the 1849 abortion ban. And that law is Wisconsin Statute 940.15. And that statute provides that whoever intentionally performs an abortion after the fetus reaches viability meaning the age of fetal development, where the attending physician determines that there is a reasonable likelihood of sustained survival outside of the womb. Whoever performs an abortion after viability is guilty of a crime unless the abortion is necessary to preserve either the life or the health of the pregnant woman. Since Roe, the Wisconsin legislature also enacted an entire statutory framework for the regulation of lawful abortion. And this is found in Chapter 253 of our statutes. And that entire regulatory scheme sets parameters for the providing of lawful abortions. So bear with me a bit because I like both nature and analogies, and now I'm going to try to combine both, so we'll see how it works. I like to think of it like this. When the United States Supreme Court decided Roe, it essentially placed a rock on the ground on top of that 1849 ban that had long been disused. And the Supreme Court said that what is beneath this rock cannot ever be law because it violates an individual liberty guaranteed by the Constitution. States can no longer say otherwise because this individual liberty is protected by the United States Constitution. So then, for 50 years, Wisconsin law grows as a tree around and above that rock. It grows taller and taller, and there's more branches, all addressing abortion with the understanding that that rock is there and it's not moving. For 50 years, Wisconsin physicians understood that abortions could lawfully be provided to women in many more circumstances than when necessary to save the pregnant woman's life. And for 50 years, Wisconsin women understood this too. And then Dobbs. So in June of this year, the United States Supreme Court issued its decision in Dobbs and held that that individual liberty that it recognized in Roe as guaranteed by the Constitution actually does not exist in the United States Constitution, and the question is up to the states. And as the dissent in Dobbs explained, this was the first time in the history of the United States where the Supreme Court rescinded an individual right in its entirety and conferred it to the states. So that rock that has been there for 50 years is now removed. And so today, at least on the books, we have two directly conflicting sets of laws in the state of Wisconsin. The 1849 near total ban and all of our post-Roe laws. There are many conflicts between those two sets of laws, but let's focus on the 1849 ban versus Wisconsin Statute 940.15, that being the viability statute, which was enacted in 1985. Those two laws directly conflict in at least two key ways. The first is the stage of pregnancy at which abortion is and is not prohibited. 940.15 says that abortion after viability is unlawful, but the 1849 ban says that any abortion after conception is unlawful. The second direct conflict is in the exceptions to the prohibition. So 940.15 says that the performing of an abortion after viability is lawful if needed to preserve either the life or the health of the pregnant woman. But the 1849 ban says that the performing of an abortion after conception is only lawful when necessary to preserve the pregnant woman's life. So let's think of, or I have a few factual scenarios, hypothetical factual scenarios for us to think about to really see the potential implications of this conflict in the law and how it would play out. The first one, a college student learns she is 8 weeks pregnant and wishes to have an abortion. Is it lawful for a physician in Wisconsin to perform that abortion? Under our post-Roe statutes, such an abortion would not be prohibited. But under the 1849 ban, it would likely be a criminal felony. A woman who is 30 weeks pregnant suffers a medical emergency and her physician believes that if her pregnancy is not terminated, the pregnant woman will suffer from a severe disability for the rest of her life. Is it lawful for a physician in Wisconsin to perform that abortion? Wisconsin's post-Roe statutes make exceptions for such abortions to protect the woman's health, to prevent substantial and irreversible impairment of her bodily functions. But under the 1849 ban, it would likely be a felony. Last one. A woman is sexually assaulted, and 4 weeks later she learns that she is pregnant as a result of the assault. She wishes to have an abortion. Is it lawful for a physician in Wisconsin to perform that abortion? Under our post-Roe statutes, such an abortion would not be prohibited, but under the 1849 ban, it would likely be a felony. So, our lawsuit that we brought to try to provide clarity to the people of Wisconsin. Attorney General Call, the Wisconsin Department of Safety and Professional Services, the Wisconsin Medical Examining Board, and its chair, Dr. Sheldon Wasserman, brought our lawsuit with the authorization of Governor Evers in the Dane County Circuit Court, seeking a declaration that 1849 ban is unenforceable. And we make two main arguments. Our first argument is that the 1849 ban has been superseded under principles of statutory interpretation. And statutory interpretation is a fancy way of saying, a fancy term for a set of rules that courts use to interpret laws the legislature has written where there is a conflict or some other question or ambiguity about what the law means. And those rules address the rare circumstance that has happened here where Wisconsin has directly conflicting laws. And one such rule is called the doctrine of implied repeal. And what that doctrine tells us is that even if the legislature has not formally deleted one of the statutes from the books, if the earlier law conflicts with the later law, or if the later law is meant to be a substitute of the earlier law, then the later law supersedes, meaning essentially cancels out, the earlier one. And it's our position that that's exactly what's happened here. Our second argument is that the 1849 ban has become unenforceable because it has essentially fallen into disuse. So there is another legal principle that recognizes that in certain rare circumstances, laws can become unenforceable through long periods of non-enforcement. So let's consider an old out-of-state example. In very, very early Pennsylvania law, women who were convicted of being a common scold could by law be punished by being placed on what was called a ducking stool and plunged into water multiple times. Now, if that were still listed, which thankfully it's not, if that were still listed on the books in the state of Pennsylvania, even if that were still listed, I doubt any of us would think that that is actually the enforceable law of the state of Pennsylvania. Now, thankfully, the Pennsylvania Supreme Court in the 1800s recognized, using in part this very principle, that that was no longer the law because that practice had fallen into disuse. And this principle of, in rare circumstances, law being able to become unenforceable through disuse, through an extended period of disuse, is derived from the important concept that, I'm going to use the word derived twice, the government derives its power through the consent of the governed. and that we are all entitled to have notice of the laws that affect us. So now let's consider the 1849 ban. There is not a person alive in the state of Wisconsin today who voted for that ban or voted for the legislators who voted for that ban. It would still be over 60 years, as I said, before Wisconsin women would be able to vote. During the roughly 100 years where this law could have been enforced, it was very rarely, never meaningfully enforced. And then, after 100 years of that, it became affirmatively unenforceable as a violation of a constitutionally guaranteed individual liberty. And so we argue that in this extraordinarily rare, narrow combination of circumstances, until and unless the Wisconsin legislature of today enacts that into law, the 1849 ban cannot be said to have the consent of the governed or to be the law of the state of Wisconsin. So that's my presentation. I will be happy to answer any questions that you have during the question and answer opportunity. I'll note I'm going to be limiting my responses to the state of Wisconsin abortion law and the issues in our suit. And in that suit, as we argue, Wisconsin physicians, Wisconsin women, and the Wisconsin public as a whole deserve clarity on this incredibly important subject. Thank you.
Thank you very much, Hannah. That was clear. Our next speaker is Dr. Dorothy Skye, who's an OBGYN. In 1982, after finishing an internship and residency in obstetrics and gynecology at the Naval Regional Medical Center in San Diego, she was stationed at the Naval Hospital in Beaufort, South Carolina until 1984. After completing her service in the Navy, Dr. Skye joined a multi-specialty medical group in Rhinelander, where she practiced as an OBGYN from 1984 to 2013. Immediately after retiring, Dr. Skye became involved with the League of Women Voters. She served as president of the League of the Northwoods from 2016 to 2020. She serves on several committees of the State League, became a state board member in 2018, and was elected the League of Women Voters of Wisconsin board president in 2021. Please welcome Dr. Dorothy Skye.
Thank you for the introduction, Dr. Crowley. I'm going to be speaking to you as a women's health physician. And yeah. As you said, I've been tasked with discussing abortion care and the Dobbs decision from a medical perspective. I'm afraid this is stark. The evocative photo from the North Dock in my backyard conveys my viewpoint on the subject. The U.S. Supreme Court's Dobbs v. Jackson decision was issued on June 24th, 2022. In that ruling, by a vote of 6-3, the court reversed lower court rulings and voided the Roe and Casey decisions that had protected women's right to abortions with certain restrictions for almost 50 years. As an epitome of our polarized political climate, that day will be seen by some as a day of righteous achievement and by others as a day of infamy. I've been asked to speak about the Dobbs decision from the point of view of a women's health physician. From that viewpoint, I think Dobbs is an ill-considered ruling, ethically, medically, and practically. I'll begin by sharing with you a couple of statistics that provide some perspective on abortion care in Wisconsin prior to the Dobbs decision. Next slide, please. Induced abortions reported for Wisconsin in 2020, 6,336. A few more than the preceding year. And we usually talk about ratios to put things in perspective. So that equates to 10 induced abortions per 100 live births in Wisconsin. That compares to the almost 20 nationally. Women ages 20 to 24 accounted for the largest proportion, 30% of reported induced abortions to Wisconsin residents in 2020. Women over age 35 accounted for 13%, and those in the 18-19, 7%, and the youngest age group, 3%. 84% were obtained by women who'd never been married, 12% by currently married women. Next slide, please. "54% of the abortions were obtained by white women, 34% by black women, and you can see the other percentages there. Over half were performed in the first 8 weeks of pregnancy. About 2/3 were surgical, 39% medical. And those statistics are from the Wisconsin Department of Health Services. Next slide. This provides a national perspective over time. It shows the changing number of legal abortions in the United States from the 1970s through 2020. You can see the downward slope. And the difference in those graphs just depends on the means by which those numbers were obtained. During my career as an obstetrician gynecologist, I did everything I could to make sure each of my patients' pregnancy experiences were safe and positive, leading to a joyful outcome. But neither those pregnant women nor I could predict with certainty what would happen during those privileged but potentially perilous 9 to 10 months of their lives. Pregnant women have risks over and above those of the general population of women of the same ages. For purposes of this discussion, I'll have to emphasize those risks and potentially adverse consequences to a much greater degree than I did with my patients during normal, low-risk pregnancies. When a woman realizes she's pregnant, she enters a new personal reality. The implications for her future are huge and undeniable. She can share her emotional ups and downs with others, but the physical risks and discomforts of pregnancy are hers alone. Serious risks include bleeding, infection, blood clots, organ failure, pregnancy diabetes, and dangerously elevated blood pressure, any of which can be life-threatening. And that's apart from the usual physical downsides that all pregnant women experience to some degree, such as nausea and vomiting, swelling, stretch marks, and various kinds of significant pain. To quote from a publication of the American College of Obstetrics and Gynecology, quote, "Forcing people to continue their pregnancies by banning access to abortion exposes them to risks associated with pregnancy and childbirth." Next slide, please. This is just the national statistics, again, for some perspective. 861 women died as a result of their pregnancies in 2020. That was 23.8 deaths per 100,000 live births. Is that a big number or not? Next slide. The next slide compares the maternal mortality rate in the United States in 2020 with that in other industrialized nations. We're that red bar at the top. We don't fare very well. The next slide shows the pregnancy-related mortality ratio. That's that ratio that I mentioned in the previous slide. And what you need to note here, non-Hispanic Black women, that's way out of proportion to their percent of the population. Black women are disproportionately at risk. Next slide, please. This, it uses jargon and the print's small, but summarizes us to say that in plain English, the major causes of maternal deaths are infection, bleeding, blood clots, and toxemia, which the latter is a mysterious disease unique to pregnancy, and I'll talk a little bit more about that in a minute. Toxemia. I dealt with that a lot. It's the reason that prenatal care became a standard medical practice in order to reduce deaths from this complication of pregnancy. Toxemia occurs with variable severity and clinical presentations. Its spectrum includes high blood pressure, swelling of the hands and face, protein spillage in the urine, liver malfunction, seizures, and both hemorrhage and blood clotting abnormalities. Pregnancy, it comes in a spectrum of various names that you might hear about in reference to you or women that you've known. Pregnancy-induced hypertension, preeclampsia, eclampsia. It's called eclampsia when it's accompanied by seizures. Fortunately, we don't see this too much anymore, but it used to be a regular event. Advanced cases of this condition are the worst nightmare for members of the healthcare team because of the risk to both the pregnant woman and her unborn baby. Either as a standalone or as a complication of toxemia, pregnant women are prone to blood clots and hemorrhage. A case in point involves a very famous woman who just retired after an astounding career in professional sports. I'm talking about none other than tennis star Serena Williams. I get a nod there. She had both blood clots and hemorrhage during her pregnancy and very nearly died. Infections during pregnancy and childbirth are treatable these days for the most part, but still represent a significant risk. Preterm, premature rupture of the membranes, for instance, allows free access of all the bacteria that are normally kept out of the uterus. Once those germs get in, they can readily ascend to infect the baby and the mother. That's called sepsis. And it was responsible for much of the high maternal mortality and neonatal mortality in times past. Currently, infections potentially wreak havoc, particularly in women who can't access health care. Finally, there are a number of well-recognized medical conditions that can put women at very high risk of worsening of their underlying disease or dying during pregnancy or shortly after. As an example, during my residency in the Navy, I did an abortion on a woman with primary pulmonary hypertension. Rare condition, wouldn't expect you to have heard of it, but this condition is currently associated with about a 30%, likelihood of death during the pregnancy, and when I was in training, it was a lot higher than that. Next slide. Obviously, an unborn baby is not going to do well if the mother dies. But what if the fetus is afflicted with a serious condition that doesn't make the pregnant woman ill? This introduces another realm of pregnancy complications that require decisions in which the government has no right to meddle. It's become standard of care to offer pregnant women tests to detect major chromosome abnormalities and significant birth defects in the fetus. An example is neural tube defects, which manifest as mild to severe problems with development of the baby's brain or spinal cord. How are we going to manage serious fetal abnormalities detected over the course of prenatal care? What's a pregnant woman to do when she finds out the fetus she's carrying has severe birth defects or chromosome abnormality that is incompatible with life or likely to result in a significantly reduced quality of life for the child and an overwhelming burden on the mother and her nuclear family? Imagine you're an obstetrician trying to gently and empathetically break the news to a woman at 16 to 26 weeks of pregnancy that the ultrasound images of her unborn baby show a major neural tube defect called anencephaly. I've been there. Which means the baby's brain and skull are mostly absent. More devastatingly, imagine that you are that woman. Prior to Dobbs, women could be offered termination of the affected pregnancy. Now what will we do? Women and their healthcare providers are presented with a new host of dilemmas and conundrums in the post-Roe world. In addition to the possibility of suffering from the time of conception from major genetic aberrations, neural tube defects, or other such abnormalities, fetuses can acquire destructive, if not fatal, infections. And Hannah referred to the prime example of that from the not-too-distant history, rubella, German measles. And there are several other similar infections that produce the same sort of devastating effect on the baby. Toxoplasmosis, herpes, cytomegalovirus, and rubella being the major ones. Next slide, please. Another realm of major concern is how Dobbs will affect women's access to infertility treatment. How are healthcare providers going to counsel and care for individual women and couples who seek help because they desperately want to carry, birth, and raise their own biological child, but are unable to do so on their own? How do we offer and manage so-called reproductive assisted technologies after Dobbs? Once again, the Dobbs decision represents unreasonable influence in a woman's most personal decisions. There seems to have been a rather shallow appreciation of the consequences of the ruling by 6-3 Supreme Court majority. Finally, another very practical matter. Will women's health care providers tend to stay in states with total or near total abortion bans, or come to those states in the first place? I think not. That's going to further reduce the availability of health care to women, especially those who already are underserved. I'm a lifetime fellow of the American College of Obstetricians and Gynecologists, the major organization to which most OBGYNs belong. That organization speaks for us OBGYNs before government bodies and for press interviews. It helps us to stay up to date with relevant clinical information and training and provides guidance about relevant public policy. An official ACOG publication designed to help OBGYNs speak on the subject of abortion services and reproductive health care states, and I quote, "While people may have differing views about abortion, Those views must not interfere with the relationship between people and their doctors. Restrictive laws criminalize physicians' duty of care. Restrictive laws on abortion place physicians in an ethical dilemma of choosing between their obligation to provide the best available medical care and substantial legal, sometimes criminal, penalties. Being present at several thousand births, I couldn't help but notice that we are each born individually. To me, that is a manifestation of the individuality and autonomy with which we are each endowed by our Creator. I just can't see why or how our representative government can rightfully or effectively seize control of a pregnant woman's body for the duration of pregnancy. And incidentally, largely drop the responsibility and the consequences on the mother at the moment of birth. As I explained in some detail, pregnancy comes with considerable unique health risks and lifelong consequences for every woman who conceives a child. The Dobbs decision flies in the face of a physician's ethical and medical responsibilities to serve pregnant patients and defies a pregnant woman's right to control her most intimate interests. In summary, Roe and Casey should have been left in place according to the principle of stare decisis, literally, let things stand as decided. I haven't addressed medical or surgical abortion techniques, the history of abortion in our country, or what I consider reasonable limits and stipulation regarding abortion services, but I'd be glad to respond to your questions in that regard. I haven't discussed the socioeconomic aspects. That's a great big topic, and I wish we had an expert to address those. But for starters, it helps to know that 60% of women seeking abortions are women of color, 50% live below the poverty line, and 60% already have children. Next slide. Here are 3 books that I found particularly helpful to understand this issue. I can tell you why during the Q&A if you ask about it. Next slide. And here's a book by one of the featured speakers of the upcoming League of Women Voters 2022 Issues Briefing. This event will take place virtually in 3 segments on November 10th, 12th, and 14th. Got it. Please register and attend. You'll be so glad you did. In the session on the morning of November 12th, historian Elizabeth Griffith will discuss how the abortion issue and the Dobbs decision fit into the overall struggle of both black and white women to achieve equal rights between 1920 and 2020. In other words, the 100 years since the 19th Amendment. Betsy has done thorough research, and she's a very engaging speaker. With that, I'll say thank you once again for including me on this panel, and I'll pass the microphone to the next speaker.
Thank you, Dr. Skye. Finally, last but not least, to wrap up our speaker's presentation, present the League's position and action plan, Debra Cronmiller, who is the Executive Director of the Wisconsin League of Women Voters. Before serving in this role, she worked in state government in the Department of Workforce Development and the Department of Children and Families. She started her career in nonprofit management, assisting adults with disabilities to enter the workforce and provide shelter and services to people experiencing homelessness. She is currently a director on the Community Shares of Wisconsin board. Debra is a graduate of the University of Wisconsin-Madison, and please welcome Debra Cronmiller for our last speaker. Thank you.
Good evening, and thank you so much for the opportunity to join this conversation. You may wonder why the League of Women Voters is so interested in being here and being heard. At the 2020 LWV U.S. Convention, LWV members affirmed that health care, including reproductive choice, was an urgent issue that we should continue to work on. The voting delegates affirmed that when that issue was front and center, the League would prioritize advancing our positions on that issue. Fast forward to June 24th, 2022. The Supreme Court overturned Roe v. Wade and Planned Parenthood v. Casey. So here we are, mobilizing with our state and national partners to be a part of this important national conversation. The League speaks with one voice on issues of reproductive justice. The League believes every U.S. resident should have access to affordable, quality health care, including birth control and the privacy to make reproductive choices. As an ally of reproductive rights organizations, we know that safe access to health care, including abortion, is essential to our democracy. Democracy depends on equal rights for all people. Losing our right to reproductive choice opens the door to the loss of other freedoms like marriage equality, contraception, and the right to engage in private, consensual intimacy. The attack we have seen on voting rights is an attack on democracy. The attack on reproductive choice is a continuation of silencing people in this country. Not only is the right to a safe and legal abortion a matter of personal freedom, it's also a major factor in the movement for racial and economic equality. Black women and all underserved communities already experience inequitable barriers and limited access to adequate health care services. Many of the communities targeted with voter suppression are the same ones who will be most impacted if reproductive right is taken away. The League of Women Voters stands in solidarity with women and individuals who become pregnant in the fight to protect and maintain reproductive freedom. The League affirms the right of all people in our country to make their own reproductive choices. Abortion should be legal, safe, and the choice of pregnant people. For anyone who experiences pregnancy, our basic freedoms depend on our ability to control our reproductive health. Our reproductive choices impact our physical and psychological well-being, including the foods we eat, our financial resources, and our capacity to gain and maintain employment. Generations before us have fought tirelessly to gain and protect the rights we have today, and we will not back down. We are in a fight to make sure that everyone has the power to control their own bodies, lives, and futures. True democracy depends on equal rights for all people. Losing our right to reproductive choice opens the door to the loss of other freedoms. It is critical that we show up and make our voices heard for reproductive choices. The League of Women Voters of the United States believes that democratic government depends on informed and active participation at all levels of government. The League further believes that governmental bodies must protect the citizens' rights citizens' right to know by giving adequate notice of proposed actions, holding open meetings, and making public records accessible. The League has long worked for the public's right to know and for broad public participation in government as a necessary component of decision-making at all levels of government. The League supported the 1976 Government in the Sunshine Law to enhance the public's access to information. In the 1980s, the League monitored and lobbied to revamp the way federal rules and regulations are made. Early in 1995, congressional leadership launched a broad attack on public participation in government decision-making. Under the guise of regulatory reform, bills were introduced to make it much more difficult for federal agencies to promulgate regulations dealing with health, safety, and the environment. These bills were based on the premise that regulations should be judged solely on their cost to the public and private sectors and not to their benefits on society. The League responded quickly to this major threat, lobbying both houses of Congress in opposition, along with members of 200 other consumer, environmental, and disability rights organizations. League members met with their members of Congress and participated in media activities opposing these efforts. This opposition succeeded in stalling all regulatory reform legislation in the Senate in 1996. Beginning in 2001, the League of Women Voters participated in the Judicial Independence Project. State and local leagues, working in conjunction with the national office, assessed the levels of judicial independence in their state and developed citizen education campaigns to educate their communities about this important issue. A key part of this program was encouraging leagues to include judicial candidates in their voter guides and to organize candidate forums for judicial candidates. In 2005, the League launched Openness in Government, Looking for the Sunshine, a project to broaden public awareness about the issues involved in and the threats related to accountability and transparency in government. The project was continued in 2006 under the name Observing Your Government in Action, Protecting Your Right to Know. The League developed educational materials about federal, state, and local laws concerning citizen access, the extent and type of threats to these laws that have occurred in recent years, and data on the increasing levels of information being placed off limits since the terrorist attacks on the U.S. in September 11th of 2001. At the federal level, the League was active in providing advice to the Obama administration from 2009 through 2017 as it proceeded to implement its Openness in Government directive. In doing so, the League helped several good government groups work together. The League served as a co-sponsor of the annual Sunshine Week in the mid-2000s. As we continue to push forward our general policy objectives, the League continues to make sure open meetings and open records laws are protected or expanded. As you know, this state league pushed for legislation to create increasing transparency and public input in the redistricting process prior to the 2021 redistricting cycle. I'm a little dating myself. The League signed on to the Leadership Conference on Civil and Human Rights report, Vision for Democracy, written in 2019, which lays out policy recommendations to ensure that everyone is able to fairly, equally, and accessibly participate in our democracy. With the Roe decision, the Supreme Court released its decision overturning our constitutional right to abortion. Writing for the majority, Justice Alito stated, "Procuring an abortion is not a fundamental constitutional right because such a right has no basis in the Constitution's text or in our nation's history." In doing so, he and 4 other conservative justices turned back the clock, not only essentially sending Americans back to a time before Roe v. Wade was decided, but also looking almost exclusively at reproductive rights from the lens of mid-1800s and earlier to determine whether the Constitution confers a right to abortion today. Justice Alito maintained that contrary to the fears of many civil rights advocates, this decision had no bearing on other unenumerated rights, rights not specifically spelled out in the Constitution, but nevertheless recognized as fundamental, such as marriage equality, same-sex intimacy, and contraception access. However, Justice Thomas undermined his assertions by penning a concurrence calling for a new look at the decisions protecting all of the above rights and more. Meanwhile, a joint dissent authored by Justices Breyer, Sotomayor, and Kagan argued that the court has stripped women of all rights thereby destroying lives, curtailing women's status as free and equal citizens, and most negatively impacting women of color and limited means. The crux of Dobbs is highly constrained and antiquated view of what constitutes a fundamental constitutional right. Specifically, Justice Alito wrote that for a right to be protected by the Constitution, it must either explicitly be spelled out in the text or deeply rooted in our history and tradition. What exactly does this mean? According to the Dobbs decision, relevant sources for gauging whether abortion is deeply rooted in history include cases and writings from the 13th, 17th, and 18th century England, cases in legal manuals from colonial and early 1800s America, and the fact that in 1868, when the 14th Amendment was ratified, 75% of the states criminalized it. Post-1868 history allowed one paragraph compared to the approximately 8 pages of pre-1868 historical analysis. This is an incredibly troubling view of constitutional protections. By discounting history after the ratification of the 14th Amendment, the court limited constitutional protection to only those rights that were recognized in the earliest days of this nation, before women and people of color were able to vote, own property, control their earnings, serve on jury or as lawyers, or virtually any other hallmark of full participation in society. Under this logic, even if there were societal or legislative agreement that abortion is a constitutional right from the late 1800s to present day, it's possible there would still be no constitutional right to it. No amount of societal change, scientific advancement, or recognition of past injustices would allow Americans any rights beyond those that a small group of white, property-owning men explicitly awarded them 200 years ago. Lack of abortion access will have a massively dangerous impact on Americans going forward. But now that we know what the Dobbs approach does to constitutional analysis, could this method affect other aspects of people's lives? While that remains to be seen, the Dobbs logic puts many, if not all, unenumerated rights that Americans have built our lives and communities around on very shaky ground. Aside from the court's general skepticism of unenumerated rights, there are many constitutional rights that have the same origin as the right to abortion, namely the right to privacy and liberty. Significantly, none of these rights were recognized either legislatively, legally, or socially in the 19th century United States. Instead, they are products of a more recent understanding that to deny such rights would be unjust and discriminatory. While Justice Alito argued that these rights are not affected by Dobbs, under the Dobbs logic, they are unlikely to be protected by the Constitution. Indeed, Justice Alito even sowed seeds of doubt in the right to privacy itself by pointing out that it is not mentioned in the Constitution, and it is unclear from which amendment it can said to originate. Justice Thomas's concurrence makes this danger clear. He stated that the Due Process Clause, a provision in the Constitution that protects people from the arbitrary deprivation of life, liberty, and property, is generally considered to protect many unenumerated rights, does not secure any substantive rights. According to Justice Thomas, any substantive due process decision is demonstrably erroneous. Thus, the court should reconsider all substantive due process precedents to, his words, to correct the error. While this willingness to strike down constitutional protection for all unenumerated rights is even more troubling than majority opinion, at least Justice Thomas is honest in pointing out that the grounds on which Roe was overturned jeopardize other unenumerated rights as well. One day before releasing Dobbs, The Supreme Court published its decision in another case dealing with constitutional rights, the New York State Rifle and Pistol Association versus Bruin, in which the court severely restricted the ability of states to enact gun control measures. The logic employed in Bruin is remarkably similar to that of Dobbs. Specifically, Bruin limited the relevant historical tradition of gun regulation to the time around the Second Amendment's ratification. Thus, Dobbs and Bruin share a focus on century-old conceptions of rights and social norms in defining present-day constitutional protections. Such a preoccupation with distant history shifts the court to an extreme version of originalism, which is a theory of constitutional interpretation that argues that all statements in the Constitution must be interpreted based on how they would have been understood or intended at the time the Constitution or the relevant amendment was adopted. In the court's new originalist world, rights are constrained, as with abortion, to their 19th century status, regardless of social change or improved scientific knowledge. At the same time, modern problems, such as the creation of exponentially more deadly weapons and the proliferation of mass shootings, do not allow for legislative responses unless they are actions 19th century legislators would have taken. Yet the most important attribute shared by these opinions is the dangerous and oppressive effects that they will have on countless people in this country, chiefly people of color and those with limited means. Women of color and women who cannot afford to travel for an abortion are most at risk of losing their lives and their livelihoods to abortion bans. Similarly, people of color are more likely to be victims of gun violence than white people. And communities of color have become targets for mass shooters, such as those who shot and killed 10 black individuals in Buffalo in 2022, murdered 23 Latino people in El Paso in 2019, and killed 9 black churchgoers in Charleston in 2015. Together, these cases demonstrate that Dobbs is not an anomaly. Instead, the court has taken a sharp turn toward depriving Americans of important constitutional rights, not just the right to obtain an abortion, but also the most basic principles on which our nation was founded, the right to life, liberty, and the pursuit of happiness. Most cruelly, its apathy for modern problems and attempts to remedy historic injustices puts people of color, lower-income individuals, and women well on their way back to a time when they enjoyed virtually no rights whatsoever. Last week, on September 16th, on NPR's Here and Now, Frederica Freiberg spoke with Charles Franklin of Marquette University on a recent Wisconsin poll on the issue of abortion. The poll asked this question: do you think Wisconsin should or should not allow a woman to obtain a legal abortion if she became pregnant as a result of rape or incest? Overall, 83% of Wisconsins said that we should allow women to make this choice, with even 70% of Republicans saying yes. Additionally, a total of 63% of respondents, including Republicans, indicated they oppose the overturning of Roe v. Wade. This is why we are here tonight. Defending our democracy is about defending our rights. State laws crafted in 1849 should not be allowed to go into effect. When there is a broad support across parties, our elected officials should create policy that reflects the will of the people. So I am here tonight to uplift the work of the League, to encourage members to join protests, rallies, and events. The League is an ally in this fight. So I'm here to acknowledge that this is hard on a personal level. Some of us may not feel comfortable talking about abortion, but we must encourage League leaders to echo Dr. Turner's sentiments in the email she sent out to all League members following the Dobbs decision. This very real threat to our reproductive rights puts people in danger, fuels already heightened anxiety, and looms as a dangerous degradation of personal civil liberties. I thank the League of Women Voters of Manitowoc for sponsoring this voter education event. I encourage all local leagues to coordinate like events and continue our work to educate and empower voters, to register voters, and encourage the active participation in our democracy. We need to be the leaders to fight off these threats to our freedoms and our rights. We need to do the work the League has done for 102 years to empower voters and to defend democracy. Thank you.
Thank you, Debra. Well, tonight I learned a lot. And because I happen to be standing here at the podium, I'm going to take advantage and ask the first question. Dr. Skye, you talked a lot about maternity mortality, maternal mortality, risk pregnancy. So a simple question, which is more risky for the woman? Which puts more danger for her health, her life, pregnancy and childbirth, or abortion?
Pregnancy, if you just want to compare the numbers. But it's obviously, as I alluded to, it's a lot more complicated than that. And again, something that we didn't have fully represented in this panel. Debra and Hannah, you both went into it some, and I dabbled a little bit. It's a socioeconomic impact.
I had heard that it was 14 times more likely for a woman to die from pregnancy than from an abortion.
If you want the number, that's the number.
I'd like to open it up for questions. If you want to come to the podium, or Ginny does not want to come to the podium, can you ask a brief question and tell us who you're directing it to?
Yes, I have two questions, if I may, for Attorney Jurss. Did I say that, pronounce that correctly?
You did, thank you.
Maybe you touched on this, but I'm wondering why the state of Wisconsin was passing laws regarding abortion when Roe v. Wade was in effect, and I would understand it to mean their laws would be moved if Roe v. Wade is in effect.
So if I understand your question correctly, I guess what we know, and I don't want to speak for the legislature here, so I'll just look at what we know historically, is that the legislature, after Roe, convened a special committee to assist lawmakers on how to revise Wisconsin's laws so that they were in conformance with Roe. And so then in 1985, they passed this significant act that addressed abortion and pregnancy. You're welcome.
And also, are there existing guidelines, or is there any way to know at this point what a potential consequence for a medical provider who is deemed to be in conflict with the law would experience?
That's a very good question. Here's what I'll say. What we're trying to do through this lawsuit is provide clarity, because right now, both of those sets of laws, the conflicting sets of laws, are listed on the books in the state of Wisconsin. And so it's our position that that clarity is needed. In terms of the specifics of what it could mean for physicians beyond that, I think what's critical from our perspective is that there are laws that are listed on the books right now that say two opposite things. And so beyond, I guess, and I'm not sure if that's, I don't want to speak outside of the issues in our lawsuit, but that's essentially the core problem that we've identified is what are the consequences and what would happen. And right now you have those two sets of laws, one set says that providing certain abortions is completely lawful. The other says it's a criminal felony. So that's what, yep.
I was told that since we're streaming this and we're recording this, if you don't come up to the podium, to the microphone, then we won't have that streamed. So if you have a question, would you please come up and ask the question here at the microphone? Do you want to come up?
Please.
Oh, yes, I'm sorry, yes.
This is a question for the attorney. I'm wondering what is the status of the lawsuit and when is it reasonable to think that it might be resolved? Because many women are suffering, and like you said, clarity is so important.
Thank you for that question. So we are still in the early stages of the litigation. We are working and committed to efficiently and effectively obtaining a definitive answer on this question as best we can, but we are still in the early stages. And so in terms of timing, I can't give you a precise answer. We're in the Dane County Circuit Court in the early stages. And so exactly how long it will take to get that definitive answer, I can't say, but what I can say is that we are proceeding in the way that we believe to be best to efficiently and effectively get that definitive answer.
And I'll just add, for practical purposes, the reputable clinics, women's health care clinics that provided birth control and abortions in our state that I and my partners used to refer women to are no longer offering abortion services at this time, so it's gone for the time being.
Thank you. Another question? Yes.
This question is for Debra in terms of a call to action for the League of Women Voters. The legislation has gavelled in and gavelled out whenever the governor has called for discussion on this issue. And with our current gerrymandered borders, you can call your legislators as much as they want. If they don't agree with you, they don't bother doing anything. So what is our workaround? What I think a lot of people would like to see is a referendum like they had in Kansas. Is it possible to get a referendum with the current legislation?
Currently, it is not possible in Wisconsin for citizens to offer a binding referendum that has to be initiated from the legislature. And I think your intuitions are probably spot on that this particular legislature will not offer such binding referenda. There are, I believe, or I wouldn't be here, I wouldn't be doing what I do for the League of Women Voters. We have power. We have a voice. There would not be so much opposition to the fact that we have this power and voice in the form of voter suppression, in the form of gerrymandered maps, if folks currently in power didn't know how big our voice was. So we have to use it, and we have to use it more wisely and more deeply than we have been using it. We have, in many of the last 50 years, going from being a state with, virtually the highest voter turnout in the nation to 67%. We need to get back to those 80, 85, 90% voter turnout rates if we want to upset the gerrymander. It's the calculus in a gerrymander is based on who voted. So if more people come to vote, the potential to upset the gerrymander is very real. If exactly the predicted people come to vote, the gerrymander will hold, and the people in power will keep that power. And this is not just here in Wisconsin. This is true throughout the nation. Gerrymanders work in both directions. In Illinois, in Massachusetts, the maps are equally and awfully gerrymandered. It just will favor the Democrats. Here in Wisconsin and some of the other Midwestern states, it's favoring the Republicans. The way, I don't care who the gerrymander favors, we don't want gerrymandered maps. We want maps drawn by independent commissions. We want maps that are accountable to the people, so our our elected officials will be accountable to us. And that's what you miss when you have gerrymandered maps. That's what you miss when people can't offer binding referendum. So, we heard yesterday, Governor Evers put out a call for a special session on the idea of the people being able to offer a binding referendum. Now's the time. Take action. Call your representatives. Whether they call you back, whether they listen to you, you will have made that checkpoint in their office. Ooh, somebody called me, somebody called me, somebody called, and they're all saying the same thing. It adds up. And when we think we don't have a voice and we don't act as a result, that's when we don't have a voice. We have a voice when we keep talking, when we keep making our positions known.
Thank you. Nancy, another question?
I don't know who to ask this question of because I don't know who knows the answer. So there's talk, and I think our audience, because it did go on Facebook and it will be out there and viewed a lot by a lot of people in the privacy of their own home. So I want to ask this question. Is it in Wisconsin a crime to personally drive or transport someone out of state who by then gets in that location gets an abortion? And second part of that, does this apply to the bus drivers or to the U2 driver or to the taxi drivers? Because that is what is out there as scuttlebutt, as truth. So whoever knows, please step up.
I'm going to have to give a disappointing. I appreciate the question. It is a very significant question. It is, as I said before, so I'm going to have to give a little bit of what is probably a disappointing answer. I know others have talked about it, so maybe others up here could. But I have to limit my discussion to what the state of obtaining an abortion in Wisconsin would be for purposes of this discussion. So I don't know if anybody else could speak to that.
I will just say that we have been working with partners in the reproductive space for literally months now before the Dobbs decision actually came down, before it was leaked, but while we knew it was on the docket and the Supreme Court was going to take it up. We have short-term and long-term strategies. Obviously, the long-term strategy in Wisconsin is to get clarifying law so that we know what the rights and responsibilities are of our healthcare systems and the rights of our pregnant people. In the interim, however, the short-term strategy is to work with the states adjacent to Wisconsin that do not have these oppressive laws on their books. Abortion services are not illegal in Minnesota. They are not illegal in Illinois. However, if we if physicians, knowing they can't perform an abortion here in Wisconsin, encourage their patient to go across the border to get that abortion service, what we've been dealing with mostly with our partners is that right, wrong, legal, not legal, but rather how do we mitigate the crush of new work in those states? And part of that solution is Illinois and Minnesota are going to send patients to Wisconsin who need non-abortion care services so that we can share the hurt with regard to providing these services through these already stretched organizations. These are, like I say, very short-term solutions. I hope very, very short. I hope our courts can come to decisions very soon. It is not fair to hold our medical community in limbo so they don't know what or how to offer the best care to the patients under their charge. These are, I feel like a bad record. These are bad times. And we're just going to have to push our way through. But the way to push through is to make sure that we keep talking about it. We keep raising this, keep this topic front of mind. We saw what happened in Kansas. Did anyone see that coming? I did not see that coming. I was very, very surprised. And it speaks to our power. It speaks to our values. And when we come and vote values and have our voice heard, we can undo it. We can make it happen.
I have a second, if it's okay. Does the state law here in Wisconsin prevent anyone from ordering medications that might induce an abortion through the mail?
So there is, and again, we have to be careful here because the issue in our lawsuit, right, is that the 1849 ban is there listed, and that says that if it's applied to abortion, that any abortion after conception, unless necessary to save the pregnant woman's life, is a felony. And that's, of course, the clarity we're trying to provide. I'm aware that as part of the regulatory scheme that I discussed, which is in Chapter 253, there is a provision that talks about, and so that's part of the post-Roe laws, there is a provision that talks about physician proximity requirements for providing an abortion. And so I believe there has been other litigation surrounding that provision. But again, I guess just coming back to the issue in the suit is that really what any of the other laws that are listed mean, because they are all built around putting regulations on lawful abortion in Wisconsin, is unclear, and that's the clarity we're trying to obtain.
Thank you. Other questions? Darlene?
I want to say, first of all, you all have given a wonderful presentation, and it makes me so proud to be a 60-year member of the League of Women Voters. I know you didn't think I was that old, but I am. My question is, many years ago, I had an ectopic pregnancy, and I nearly died from it. Now, what would be the, would there be any problems with that today in terms of the medical aspect, or how would that go with current law?
That depends on what the law says. That depends on what the law says. A tubal pregnancy cannot come to term and deliver. It's going to burst the tube and bleed. But it was conceived. A tubal pregnancy was conceived.
So you're saying if we're talking from conception, that is from conception, that particular law? The 1849 law, unless her life is in imminent danger? Is that my understanding? Does it have to be in imminent danger, or it's clear that that would be eventually putting her in danger?
So I believe to your question about the exact phrasing of what's commonly referred to as the 1849 ban, the Exception is when it is this is the quoting from the language, necessary to save the life of the mother.
So is that a gray area to say it will eventually be necessary because it may not be necessary at that particular moment?
By that law, I think it's pretty clear that you would have been able to be treated, so you didn't bleed to death. But that was a conception.
We had another question. Do you want to come up?
Todd Bergman from the Valders Journal. Last time I was here, I attended a story on mental health or a meeting on mental health court. So I'm wondering then, what is the mental health impact of a woman after, if it's a minute after or 50 years after she had an abortion? Is there a problem with her being concerned that she took away a child's right to life?
I think that was most effectively addressed, as far as what I have read and studied, in the Turnaway study. It was a study that involved women who were recruited at abortion clinics throughout the United States over a three-year period, and they were interviewed, they were asked to join this study when they came in, when they were right around that cutoff, the 22-week cutoff. And the women who were under the cutoff and got their abortion were followed and compared with the women who were too late and didn't get it. And they were followed again, but with various parameters, statistics if you want, and they also, a number of them underwent extensive interviews for at least 5 years after that. And there's a lot of marvelous detail in that study. It's one of the books that I put up there at the end by Diana Green Foster. And it's hard for me to put it in 10 words or less, but women are resilient either way. The effects on their income, on their economic achievement, on their academic achievement, on the welfare of their children, how well their children were doing, was better. The group that were able to get an abortion. There weren't huge numbers one way or the other, but that study, I think, pretty clearly refutes the notion that abortion has a severe long-term adverse effect on a woman's mental health. I believe it was C. Everett Koopes, the Surgeon General under Reagan, who was asked to study look at all of the stats and show that abortion really did hurt women's mental health and emotional well-being and so forth. And Koopes, who himself was opposed to abortion, did a really thorough job, and he couldn't find it. He couldn't substantiate that. And so that didn't get published. You didn't say anything about it. That just kind of quietly disappeared. But I would implore all of you to read at least the highlights from the Turnaway study. And that's been referred to again and again. Almost anywhere you see statistics referred to on those issues, they come from the Turnaway study. And it was rigorous. It was really well done.
Dr. Skye has given a very thorough answer. I was trained as a social psychologist, and I can tell you the work that was done looking at women's mental health, women's attitudes, women's responses after an abortion was one of overwhelming relief. And of course, there is a big range of emotions and a big range of reaction, but the biggest one was overwhelming relief, if that answers your question. Another question?
Yeah. I will see if I can do this. My thinking is on this, are there other laws that are antique laws around here? Like what is the one, slavery, you know, like black people going from one country to another, privacy, not privacy, you know, from the black people to the white people country area, slavery. But they moved this, they send these people over and they leave here from the South, and then they have to be sent back. Do they do that here? Mm-hmm. Slavery. You ever heard of that?
Is that a question for me?
Yeah, anybody.
So, I mean, slavery is unconstitutional, right? And that's...
Are you sure?
That's stated under the federal constitution.
Or will another judge will say, we could do that again. Well, that's going to happen here. Anything would be changed.
So, I guess the constitutionality is not something that our lawsuit concerns, and so I don't know, I know you spoke about that, if you want to speak more about that.
Yeah, I think in the instance of slavery, we have federal law that now is, in place that would prohibit those actions from ever returning. But I think you're onto something when you think about if an existing federal law is overturned and states have not or have failed to update antiquated laws, as is in this case, that it just creates this legal stranglehold on the state to try to determine what are the options for our medical professionals. In the 1849 law, a woman, can abort a child without penalty. It is only if a medical professional assists her in doing so. So it's, you hate to say those kind of words out loud. It's sticky and nasty, and we do not want to be in this place, which is why we want the DOJ as quickly as possible to render clear and decisive decisions with regard to what are the rights and responsibilities of all those involved in reproductive choice.
Thank you. Donna?
Thank you for being here tonight. Attorney Jurss, if the results of the turnaround study suggest that a woman's mental health is more stable after with an abortion versus without, then if you apply that to the 1849 ban, stating that the abortion has to be necessary to save the life of the mother, could the argument be made that it saves her mental health, therefore her life?
That's an interesting question. What I would say is, I guess what I'd say is this. One of the conflicts that we see between the 1849 ban and the post-Roe laws is that the 1849 ban makes only the exception when it's necessary to preserve the life of the pregnant woman. But the 94015, which is the law, the viability law enacted in 1985, says when it's necessary to preserve the life or health of the mother. So I think that's just a further illustration of, again, how these two things just conflict. And that law is only one of the many laws enacted in Wisconsin after Roe that envision a whole network of regulation on abortions that are lawful with particular conditions.
Thank you. More questions? Yes.
Okay, thank you. Not totally my question, but somebody asked this in part, and as you talked, I'd like some clarification. And I'm thinking I might be able to get this just by calling a pharmacy, but I haven't. Is what's called the Plan B still available in Wisconsin, the morning after pill, or not? And then is the medication, and I don't even know what it is, that was prescribed for medical abortions, which is a new term to me, still being able to be prescribed, or is that not anymore because of this last Supreme Court ruling? Is that clear, my question? Whoever can answer it, I guess. Yeah. Maybe the doctor, yeah.
I ought to know that, but I don't, since I'm not currently prescribing, whether or not Plan B, the so-called morning after pill, is still available. You got me on that one. As far as medical abortion, which is certainly safe and effective in the first trimester, the first 12 weeks of pregnancy. And again, the American College of OBGYN has statements about that, the clinical particulars of how to do it and so forth. And I presume that it is not available in Wisconsin either, only because, to my knowledge, reading about the Wisconsin law prior to the reversal of Roe, is that physicians had to personally counsel the women and personally prescribe any medicines involved. But the medicines themselves, there's two. It's two. The first is misoprostol, which is used to be used as an antacid. It reduces the risk of ulcers from corticosteroids. And then somebody found out, incidentally, that it can cause uterine contractions and it can cause relaxation of the cervix. And then we started using it to do inductions at term. Instead of using Pitocin, this IV drip, you could put in this Cytotec vaginal suppository, and when a woman had gone way after her due date, there was other indications for an induction, and the cervix would relax and the labor would start, and we'd come in the next morning to start Pitocin, and it wasn't even needed. So that's how that medication was brought into service. The other one, mifepristone, is in effect an anti-progesterone, and progesterone is necessary to maintain the pregnancy from very early on. So you give the combination, and it medically induces an abortion.
And I would just offer too that we have partners in this space at women's health organizations, the OBGYN folks, the Planned Parenthood folks, and they have put out a wealth of information about how to procure drugs, not in Wisconsin, but online from out-of-nation providers sometimes and that sort of thing. Dorothy is absolutely correct. Everything I've been told from those providers is that there does need to be a medical professional providing guidance. So it's not just you can't, go online and just order something up and get it in the mail. We do have to go through the medical counseling to ensure that it's right for you as a patient.
Thank you. We're running out of time. I think we have time for one more question. You have someone who wants to ask a question? If not, Debra, Dorothy, and Hannah, thank you so much. Thank you. I appreciate your time and your information and your knowledge. Thank you.